Good afternoon, everyone, and thank you for making time to join us today to talk about all things Prohibited Transaction Exemption 2020-02, the corresponding retrospective requirements, as well as hearing from our expert panelists from a practitioner's perspective. A few quick housekeeping items before we get started. As you can tell, we are recording today's conversation. With the supporting slides, you'll have access to all of those following today's conversation. We certainly encourage you to participate and engage in the conversation. Please use the chat box at the bottom of your screen to submit any questions you have throughout today's session. We've allotted plenty of time near the end of today's session to address them. That's the purpose of today. And some of us may be working from home, so some of us may be working from the office. You may hear some sounds, background noise from time to time. We appreciate your patience. All right, to get our all-star panel introduced, let me welcome our expert panelists. I'm going to ask for our panelists to introduce themselves, starting with Teresa Menderski.
Hi, good afternoon. Param, thank you for including me in this important panel. As you can see, my picture is pre-COVID, so please ignore that. But I'm Teresa Menderski. I'm currently the CCO of the broker-dealer and municipal advisory at Davenport Company. We are a small to mid-sized diversified firm in Richmond, Virginia. I've been with the firm approximately 12 years, and I also serve as the AML compliance officer and handle Reg BI and DOL issues and initiatives.
Thank you, Teresa. Candy Pallucci.
Yes, hi, thank you, Parm. Good afternoon, I'm Candy Pallucci. I am a senior consultant with Oyster Consulting, handling compliance consulting and CCO outsourcing for several firms like yourself. It's nice to be with you today.
Excellent. Mr. Wagner.
Hi, everyone. Thanks, Param. And Teresa, I think everything about me is pre-COVID, so the apologies. But I'm Ed Wegner. I'm Managing Director of Oyster Consulting, and I'm also the practice lead for governance, risk, and compliance for Oyster. I've been with Oyster for just coming up on 3 years. Prior to that, I was a regulator for most of my career. Most recently, I was with FINRA, and I was the Midwest Regional Director.
Thank you, Ed. Mr. Randy Barnes.
Thanks, Param. Hey, everybody. Randy Barnes, Director of our Product and Sales Engineering here at InvestorCOM. Been in this wonderful world of wealth management fintech for just shy of 25 years. Been with InvestorCOM for just over 1 year. So thanks for having me.
Welcome, everyone. And my name is Parm Nasseri. I'll be the moderator and host for today's conversation. At InvestorCOM, I head up our product and our regulatory strategy. And if you haven't heard of InvestorCOM, we are a leading regulatory software provider for wealth managers across North America. Our award-winning and intuitive design has helped firms grow their practice as well as mitigate compliance risks for over 30 years. Okay, with that commercial out of the way, let's jump in. What are we going to talk about today? We'll begin by reviewing the DOL's retrospective review requirements, and we're really going to be looking at this from a practitioner's perspective, given the deadline, given the community that we've built in supporting you on this side of the fence. And then we'll dive into myriad of topics, including streamlined testing. Do you sample? Do you look at the population? How do you monitor? And how can technology help you given the deadline? And lastly, we'll dive into sort of what's next. There's been a court case. There's been appeals dropped. There's been also news that there's potentially a new fiduciary proposal in the works. So we'll spend a little bit of time focused on that part of the conversation as well. And as I said off the top, we've allotted plenty of time to address your questions. There's been plenty of questions that have come in ahead of time as well. So certainly engage using the chat box on your screen. Excellent. So prior to the webinar, we engaged all of our attendees and asked a few poll questions. And really our purpose behind that is to better understand how you and your peers are tackling the requirements. And so what do we find out? We first asked about what you're finding most challenging with respect to the PTE 2020-02 requirements. And as you can see on the screen, the disclosure and documentation requirements are still front and center for most. And as you can see on the sort of furthest right-hand column there, the retrospective review requirements are still front and center for folks. So let's keep the poll questions rolling. We asked, how are you making best interest product and rollover recommendations? The majority still tackling that manually. Having said that, and having asked this question over the course of the, I'd say 2 years, it's interesting that we're seeing that number of folks who are leveraging technology trickle upwards, and certainly encouraging from our perspective. We'll dive into that in a bit. More detail soon. And then we asked, why are you not adopting technology? So if there's any hindrances, let us know. And the predominant reasons, as you can see, is limited time and resources, which I'm sure folks who are working in a regulatory compliance capacity can all relate to. And as you can see, the other sort of main or predominant reason is the traditional sort of relying on manual PDF forms to as a workaround. We also asked, how do you plan to meet the retrospective review requirements? Topic of the conversation. 71% will be doing a manual audit. Others will be relying on advisors to sort of do a self-audit, and then certainly engagement of outside compliance and legal experts is front and center. So we'll kind of jump into kind of the pros and cons of all of those in today's conversation. And finally, what technology are you using to meet the retrospective review requirements? Sorry, what methodology, not technology, are you using to meet the retrospective review requirements? Are you sampling? Are you reviewing all rollover recommendations or taking a risk-based approach? So interestingly, out of the 48 respondents we received, majority are reviewing all rollover recommendations, which certainly technology can bring to life fairly readily. Again, we appreciate your thoughtful responses to these questions and engaging with us. It certainly has been somewhat of a thought-provoking exercise for us, to say the least. Let's use this as a backdrop and jump into the conversation. We've got some form of a deadline on the hopper, and maybe this could be a good point for me to start. And I heard some feedback, but let me just continue. Candy, let's start from the top. Everyone by now should know what the prohibited transaction exemption 2020-02 is all about. But can you sort of provide a quick overview about what the requirements are all about, and what should our audience know about the requirements?
Yes, can you hear me okay, Parm?
Thumbs up.
Okay. Okay, good. Yeah, so like you said, most people, are very well aware, especially probably all of the people on this webinar today. But ultimately, what the exemption is attempting to do is protect investors' interests in relation to retirement assets, and also allowing fiduciaries to earn a reasonable compensation for providing investment advice to retirement plans or participants. So in order to do that and qualify for the exemption, firms have to do a few things, meet a few standards, which are adopting policies and procedures, comply with impartial conduct standards, more so than fiduciaries are already doing, provide certain additional disclosures to retirement investors when they're discussing retirement plan rollovers, and also to conduct an annual review, as we'll get into further later. It's also important to note that this entire exemption in the rule, as far as being a fiduciary on a recommendation, applies to the recommendation of existing IRA transfers from one firm to another firm. So that's something to be sure you don't forget in this process.
Thank you, Candy. That's fantastic overview. And as someone who's been leading the practice at your firm, I'm sure you get exposed to sort of seeing a myriad of different practices across the industry. What are you seeing there? And if you could sort of summarize it, what's the current state of compliance as it relates to this retrospective review requirement?
Yeah, I mean, it's a great question, Param. And, just having been a consultant now for, a few years, probably the question that I'm asked most often is, what are my peers doing in this space, especially with respect to new rules? Because as new rules come out, there's often a lot of grayness. And, it's good for firms to understand what others are doing so they can see if they're an outlier, what they need to do in that space. And, firms and the DOL have been dealing with this fiduciary issue for quite some time. It's been a very long and winding road. And as we get into, the court challenges and the potential for new rulemaking, it continues to be a long and winding road. But, with respect to this PTE in particular, firms have had a fair amount of time to prepare. The rule went into effect in February of 21, and enforcement was delayed for the most part for most of the requirements until February of 2022. And then the enforcement specifically with respect to IRA rollovers related to documentation and disclosure requirements was postponed even further until July of 2022. So, there's been quite some time for firms to get prepared to comply with these requirements. And, as a result, for the most part, when we've been dealing with our clients, most of our clients are prepared. They have their policies and procedures in place. They have their processes in place. They're just now dealing with implementation issues, one of which is the retrospective review. One thing that we're seeing is the major area where processes differ is around the level of technology and automation that firms are using. Your slide was great because not only does it kind of show over time as we've been doing these panels, how that breakdown has been changing over time. It does provide some information about what other firms are doing. And while manual processes continue to appear to be the main way firms are complying, it does seem like technology is catching up. And we've talked in previous panels about some of the challenges that firms have in dealing with a manual process. And, I think that does impact the retrospective reviews. In terms of the retrospective review requirements, we've seen that most of our clients have been very diligent in getting those completed. We've had some firms that have broken up the review through different points throughout the year, culminating in a final review and report with the certification. Other firms are just tackling it, one review at a time. But, we've also seen in some cases and heard anecdotally that there's still several firms that are behind in terms of getting their testing done. And, you have the slide up with the different potential dates that this is due. I think conventional wisdom is that it's due at the end of June, but, even that's a little bit gray depending on, the way the requirement was written. The important thing, though, is that it's due soon and that firms really should get on top of it. So we've been helping a lot of firms catch up on their testing and get the first testing done for this year. I think the results of the testing, the Candy's going to get into that, but it's the typical things that you would see with the rollout of the new rule. The one question that we're getting probably most often, though, is the issues with respect to the Florida court decision regarding rollovers. I think we've already seen a number of questions that have already come in the chat here. I think before we introduced ourselves, we were getting questions about that, and that makes sense because it does, it does lead to a lot of ambiguity. The decision was very narrow and really focused on the application of the 5-part test to rollovers, but has a big impact on the rule because that's one of the biggest lifts that firms have with respect to this. But one of the things I tell clients is that we're not attorneys, and one of the things that I would suggest is before making any changes to your policy with regards to this, that you do talk to your attorneys, inside or outside counsel, to really understand the potential impacts that making any changes would have. Some things to consider in that space, though, I think are, one thing is that the SEC reiterated in recent guidance that rollovers are subject to Reg BI and the fiduciary requirements of the 40 Act. And the analysis that the SEC laid out in their recent bulletins is very, very similar to the analysis that the DOL had in their PTE. So one important thing is to make sure any changes that you make that you're still complying with Reg BI and the 40 Act. And also it's anticipated that, the DOL has announced that they're going to be doing some more rulemaking in this space and likely will be revisiting the 5-part fiduciary test. I would anticipate that they're going to address this issue about rollovers there. So I think that, those are things to keep in mind when considering whether to make any changes. Another thing that's really important to keep in mind, we saw one question is just the DOL sort of dying on the vine as a result of the court case. And that's definitely not the impact because the decision was very narrow on that one piece of guidance in the Q&A that they had, and it leaves intact the remainder of the requirements. And so those are not impacted. So things like the retrospective review requirement and the impartial conduct standard, those things all still stand. So it's important to know if you are going to make changes, what aspects the court case impacts. So more to come. Sorry, I can't be more precise there, but that's just sort of where we are right now in this long and winding road.
And thank you. That's a fantastic overview, and I think adds a lot of clarity to somewhat of a, to your point, somewhat of a winding road. And given the deadline, I'm sure it provides clarity for a lot of our audience here today. Teresa, welcome again. Let me sort of point the mic your way. You have firsthand experience of dealing with a lot of this ambiguity, whether it starts from implementing the prohibited transaction exemption requirements all the way to meeting the retrospective review exercise. Would you mind starting sort of sharing some key outcomes or learning outcomes with your peers around that process in and of itself?
Absolutely, absolutely. Thank you. I would say start early, but we're probably a little too late to say start early. So, we started ours a little bit early, and the first thing that we did was look at our WSPs. That is one of the 5 requirements, is to have policies and procedures. And one thing that's interesting about the policies and procedures requirement is most of us that are under FINRA and SEC requirements, it says we have to have WSPs that are reasonably designed, but the DOL says that it must be designed in a prudent manner. So there's a little bit of nuance in the wording there. So that's the first thing that we did, was actually look at our WSPs. We had an outside consultant review that for us, and we had some items that were missing that we needed to update. Then look at your methodology. What are you looking at? There are 5 parts to the exemption. Are you complying with the impartial conduct standard? Have you communicated that impartial conduct standard? How have you communicated that impartial conduct standard? I'm a big fan of saying it's not just one and done. You can't just communicate it and then put it on the shelf and say that you're done. You always need to re-communicate. You need to look at your training. You need to look at your WSPs, your disclosure requirements. Are you, in some instances, using your Reg BI disclosures? I don't think you can have DOL PTE without the Reg BI, and I tend to marry those a lot in these instances, because you have to provide a description of your services. Well, that's the same thing you have to do with Reg BI and Form CRS. So how do you do that? How do you provide those disclosures? How do you provide your material conflicts? How do those get to the client? The fiduciary status, and that was required to be delivered back in February. How did you do that? How did you do that mailing? Did you review that? Do you have documentation of how those clients went? What was your methodology? How do you substantiate that that was mailed? Did you create your own fiduciary language? Did you use the DOL's language? And then how do you have that for new accounts or for ongoing relationships and for prospects? How do you get that out to the client? So, and it has to be, under the meaning of Title I of the Employee Retirement Income Security Act or the Internal Revenue Code. So making sure that is correct. So you're looking at your methodology. You're looking at that fiduciary statement. Does it make sense? Are you capturing all the required elements? Then looking at your sample size. What is the sample size? How many rollovers did you have across that time period? And the time period that we chose to look at was from February 1, 2022 to February 1, 2023. So we were able to pull that data and then select a sample size, and we picked two different approaches. We looked at all new rollovers, so meaning new accounts that were opened, and then we looked at rollovers that were received into existing accounts. So we had two different sample sizes to look at, and then we broke that sample size down into how would we determine best interest. We looked at the age of the client, we looked at the asset sizes of the client, we looked at the account choice of the client. Was it a commission-based account versus a fee-based account? So we looked at all that type of data to determine a best interest. We looked at the rollover forms that were received. Were they completed correctly? Were they, in some cases, were they not completed at all? Did it make sense in the categories that we selected? Did it have the right disclosures provided? Did if it was a higher cost, why? Was there notations made as to why that was in the client's best interest? We all know that cost isn't the only factor, but it's an important factor. So we looked at all those items, and then we reduced it to writing. Well, how do you reduce it to writing? What does your final report look like? What are you going to present to senior management? How are you going to present that to senior management? When are you going to present it to senior management? And how is that going to be signed off on? So we presented ours to senior management, had it signed off, and then we also presented it to our audit committee and to our risk committee. We wanted to make sure that the firm and those that were in a position to make decisions, and those that, we wanted to make sure the compliance culture and the culture from the top. And I know that sounds outdated sometimes, but it's still very important that everyone understood that this needed to be seen, this needed to be heard. And then any of those recommendations that we had based on our findings were then reported to our centralized supervision unit. What did we find in their WSPs that were missing, that needed, did they need more in the escalation area? Did we need more training and communication to the field? As far as, one area we found was the Form 5500 wasn't being used. They were utilizing more benchmarking. Well, reiterating the importance of asking for that form, explaining to the client why that form was important. If the client didn't want to provide that form, didn't have it, making sure they included a note that was sent back to the client that said, client did not provide, explain the importance of, and then making sure the proper disclosures about, what they could do instead of rolling over. They could keep it in their plan, they could take it out in cash, what type of disclosures were there. So then we looked at all that, and then we presented our findings. And that was a very quick nutshell.
Teresa, that's phenomenal. I'm sure our audience values your input on that. I think to your point earlier, sort of being able to weave in the BI requirements with what the DOL is requiring, and sort of looking at this a little bit more kind of holistically / strategically is key for a lot of folks in the industry. And so, Randy, let me sort of turn this into a little bit more of a kind of practical perspective. You've helped over 30 of our clients digitize that rollover process. Any key observations from your lens?
Yeah, a couple really come to mind. One is the fact that we're hearing and seeing from a lot of different folks that this concept of this ever increasing and more complex regulation is really a pain point for their financial professionals in growing their business, right? I think we've seen a couple different studies, and one of them pointed to roughly 40% of the respondents said that this was the number one thing that is really a concern for them in being able to grow their business. So what that illustrates to me is just the significant value in bridging this divide between being compliant and being easy to use and adoptable in whatever your practice is, right? And then, kind of further to that point a little bit, we do focus a lot of our conversations, with our clients in sessions like this around the compliance perspective and being compliant. I don't want to lose sight of the fact that if we do this well, this can be a recruiting and advisor satisfaction thing that ultimately then can help you guys grow your businesses in addition to being compliant. So it all kind of really revolving around that theme recently, which is make it easy, make it adoptable so that, you know, it's less of a hindrance on being compliant. Everybody's got to be compliant. We want to make sure that we can reduce those barriers.
I totally agree, not just because we're colleagues and we work at the same company, Randy, but I've had to personally kind of try to, you know, pull the plan fee levels out of the Form 5500 database. It's a timely exercise, and it can certainly bring some efficiencies to that advisor's workflow, and to your point, fostering growth and adoption at the end of the day, which is why we're all here for.
You know, one of the things that we do a fair amount of vendor assessments across, not just with, you know, this in Reg BI, but across different areas of compliance. And, you know, one of the factors that's always a high priority for firms is that ease of use. And because what they want to make sure is that it's adopted in the field by their reps. And that's the biggest pain point, is if the reps and advisors in the field don't adopt, you know, it's going to be a real big challenge and a nightmare. And that's one of the big challenges with the manual process as well. It can be one of the big issues.
Yeah, and I think also to that point, I neglected to say this before, but every firm's a little bit different, right? I mean, we have to be compliant, but we've got to be compliant in our way or in your way, right? So being able to put your stamp on whatever you roll out is also got to be important. Like, it's got to be relevant to you and your business model and your policy and procedures. And so, you know, that's it. Just again, kind of goes to that point of, if it's not relevant to me, if it's not easy to use, why am I doing it? Why am I even going to bother with this process? It's just going to be more cumbersome for me.
This is fantastic, and I see the questions are trickling in. A quick reminder for folks: as questions come to mind, please engage the chat box, and we'll address them at near the end of today's session. Ed, there's another question that comes to mind. It's been front and center for, I'd say, the larger BD community out there around, hey, I'm not really making a recommendation, I'm only following an educational exercise. What risks do you see when it comes to that particular area? Yeah,
we've seen that as well, and not just with this PT. We've seen it, you know, back when, you know, under suitability and Reg BI, anytime that the triggering action is a recommendation, and there are risks associated with saying that we're not making a recommendation. But that all being said, that firms don't have to avail themselves of the PTE if you're not making a recommendation or you're doing solely educational communications. But, you know, firms have to be very cautious when claiming that. They're relying on the activities of their advisors and the reps in the fields and the communications that they're having with clients when compliance isn't there, in order to be able to make those claims. And you really have to be cautious of an advisor or rep inadvertently making a recommendation and blowing the FERD's exemption. So it is something that firms can do, but they have to be very cautious about it. What we've cautioned firms is, if you're going to do that, you really have to make sure that you have clear policies about what is allowed and what's not allowed, that you provide regular training to the reps and advisors so that they understand those policies and what they can and can't say. And importantly, you need to monitor for indications that recommendations are being made. So you can't just say, well, you know, we told the reps this, we trained them on it. You need to look to see if there's indications that recommendations are being made with regards to this. And importantly, I would anticipate that if you're going to make the claim that you're not making recommendations, there's going to be a level of skepticism from the regulators when they come in to do the reviews. So it'd be extremely important to document all of those efforts, document your policies, the fact that you communicated those policies, the training that you did, and your monitoring efforts, just so that you can show the regulator that we're not making these recommendations. Here are the controls that we have in place.
And I would say, and this may be an unpopular opinion, but if a client comes to you and says, I hate my job, I'm leaving, I just want to roll my IRA, my 401k over, just put it in an account. Well, you make a decision or a recommendation as to the type of account. And if you've read the recent SEC guidance, Well, you made an account recommendation is a recommendation. Well, now you've made a rollover and that's the first recommendation is that type of account. So I think in some instances, you may only give education as to what to do with the rollover, but now you've made an account recommendation. And I think it's very, very difficult and it's a very fine line to walk. So I agree with Ed. Your WSPs and your communication and your training, if it's not a self-directed account, I think it's very hard to defend that, but I am not an attorney. So I'm just saying that's kind of the opinion that we share here. It's very hard.
We constantly get scenarios. Yeah, absolutely. We constantly get scenarios. What about in this case? Is there a recommendation? What about in this case? Is there a recommendation? Somebody comes, they give different options, and then the rep closes their eyes and lets the client pick which one. You know, all of these different things. It's so nuanced, and it's based on a lot of case law and things and guidance. They point to FINRA's guidance with respect to recommendations related to suitability, those types of things. And do you really want to put those determinations in the hands of your reps in the field, who not only it's really complicated, but you know, clearly they would benefit by the rollover. So they're conflicted to some extent too. So you really have to be cautious if you're going to go down that path, I think.
I love the point about sort of the March 2022 staff bulletin around account types and the point you made, Teresa, around recommendations. I think if I could highlight one key sort of nuance, yet an important one in the industry, is there could be recommendations are not the same thing as executed trades or opened accounts. There is probably a one-to-many relationship there. From an account that's open, there may have been 3 recommendations. I'm just sort of extrapolating or coming up with numbers, but similarly on the product side, right? So if a VA trade was taking place or executed, there could have been 3, 4, 5 different recommendations that sort of led to that trade being executed. So I think that's an important subtle distinction that I think we need to share with our audience here today. Let me fast forward a bit, and Candy, if I could let me just go to the next slide here. We're here to talk about retrospective review requirements. I see the questions trickling in. I'm sure you've advised many clients about the set of requirements, and with the deadline around the corner, what do you believe firms need to know and be aware of?
Yes, I think on top of all the information that all the panelists have provided, which has been excellent, I think first and foremost is just the deadline, right? That there is a deadline to this. And like you said, it's fast approaching. So that's either June 30 or July 30, based on what your review period is. And there, you know, the exemption specifically states that it needs to be signed off by senior management by this deadline. So, or within 6 months of the period's end. So I think that's the most important thing, is that it's not like kind of the annual reviews that we do, the 3120s or your RIA annual reviews, where there's a little flexibility, right? And just getting it done annually, but this has a specific deadline to it. So I think that's one of the most important things to recognize. And then as Teresa detailed, you know, a lot of the things as far as setting up your process and your procedures and how you'll break down your testing. I think the thing to note is that you are essentially going back through the entire process that you did when you set up this whole program, right? You want to review your policies and procedures again, do that kind of in its own piece, if you will, and revisit the rule, revisit any interpretations or any guidance that may be out there, to see, do you still think that your policies and procedures are sufficient, or do they need more detail? I think most firms that I've worked with are finding they do need to beef up their procedures a little more and or their process, now that they look at it a year later. And then, you know, then you'll get into your testing. What kind of testing are you going to do? And I think what I've found is, for small firms, maybe it makes sense to review all of your rollovers. Like, you know, that really gives you a good indication of exactly what's happened in your firm. But for larger firms, that's not possible, really. It's more about sampling. And but I would always encourage anytime there's a sample to do it on some type of a risk basis, right? You're looking at certain age groups, you're looking at certain dollar amounts, make sure you're covering all of your branches or different offices, different advisors, just to make sure you're getting a good indication of how it's being handled across the firm, and not just in some select locations. And then the next thing is that it does have to be reduced to the written report. You have to complete this report and indicate what your review consisted of. How did you approach this? And give some detail to that. What did you find? Were there any deficiencies? Have you made any improvements around those deficiencies? Another specific thing that should be in the report is, did you find any violations or do any self-reporting throughout the year? Maybe you've already done that. You're not just finding that, you've already done that, but that should always be kind of building up in a file for your next annual review if you made any of those, and those should be included in that report. And then senior management, there are some specific, I think it's maybe 2 or 3 specific things that senior management is certifying when they read over this report and sign off on it. And I think in the preamble, the DOL made a note that, it's very important for senior management to actually review this report, know what the process is at their firm, understand where you are in compliance. Do you have some challenges that you need to address? Do you have areas of training that need to go on, but not to just sign off on the report, and expect that your CCO or whomever has handled it and you're just signing off. But I think that's important to note, is that they made a note to point out that you really should understand what you're certifying to. And there are some specific certifications that you're making when you sign off on that report.
Andy, thank you. There's plenty to review. There's plenty to do, and certainly we've tried to play our part in being helpful here. We've provided some sample text from a senior executive certification that'll be made available after today's webinar. So certainly check that out for folks who've got questions there. And I love the questions that are trickling in. And one of the areas that we get asked about a lot, Ed, is there's the policies and procedures and training reps, and then there is augmenting that with a repeatable and consistent process. What have you seen in practice when it comes to that?
It's not very different than what we see in any respect with in terms of having a set of policies and procedures and then implementing those procedures. Regulators are going to come in to determine both that you have reasonably designed procedures and that they're being implemented effectively. And so we've seen a lot of situations. I'd seen this as when I was working with FINRA as a consultant, where firms have really good policies and procedures in place, and where they fall down is in the implementation. And with this in particular, and to some extent, similar things like reasonably available alternatives on the Reg BI side, where we see some significant implementation issues is with respect to the amount of discretion that the firms are providing the reps in order to determine how they're going to comply with the requirements. And what this can lead to is very inconsistent application. So if you just say, hey, rep, here's what you need to do, here's our policies and procedures, put a comment in your, in the file, or put a comment in the CRM and those kind of things, it can lend itself to inconsistent application. You might have some advisors out in the field that are doing a fantastic job and others that are just doing a really poor job. So what we like to caution firms to do is to make sure that they have a defined process in place that allows for flexibility where necessary, but a process that they can communicate to the reps and make sure that they're following. And we found that whether it's manually done, which it can be manually done, or tech driven, it's important to create that repeatable process because it both provides support to the reps and advisors so they understand truly what it is they're supposed to be doing, but also for the compliance department so that they can, maybe get a little bit of sleep at night knowing that, they're getting consistent application of the procedures. Because I think the challenge for compliance folks is when the regulators come in, is that they look at the policies and procedures and say, great, those look terrific. And then they go out and start testing. And that's when people start to get a little bit queasy. So having a repeatable process in place I think is really important. But you also need to allow for some flexibility there. So because each situation is going to be different and your advisors might have different types of businesses that they're engaged in or clients that they're dealing with. So having some flexibility is okay, but it needs to make sure that you're getting consistent application.
Thanks for that, Ed. And Randy, considering the retrospective review process, I know we've talked a lot about sort of this term, regulatory archaeology. How do you, if you were sort of sitting in a compliance officer's shoes, how important is it that to have access to all of that data, all of the documentation and disclosures in your respective view?
Well, hearing everything that Ed and Teresa just talked about, I'd be scared out of my mind if I didn't have some sort of a centralized process that was that I could, easily get my hands on. I mean, this term archaeology is so appropriate. You've got to go digging for the manual. If you have a decentralized manual paperwork process, and these documents could live, out in the field, or even if you have a decentralized systemic process, Ed mentioned before, potentially doing some note taking in your CRM, or even storing a document in your CRM, it's still out in the field, right? And having the access to that to really thoroughly go through your test transactions, and if you wait until you're testing it, right? And understanding, was everything done correctly? Was everything filled out properly? And if not, does that then trigger, well, do I need to follow up more with that particular financial professional, and then go back out and do more excavation with that person to get more of their recommendations, because I need to see if there's a pattern or a trend? I mean, all this, I would be very, very concerned if we had to do that manually. And, we talk about it from the perspective of this back testing, right? Being able to do it there. I was just talking with some folks last week, and they recognize that they need to do this testing process like on a bi-weekly basis, because there's just so much that they're trying to look at that they need to stay on top of it. So that again just kind of begs for more of that consistent centralized place where you can get access to the data, access to the documents, do your reviews on a timely basis, so that come the time for the retro review, it's not as overbearing and as cumbersome as it could be if you just wait to do it once a year.
That's a really good point, Randy. And I think we're seeing the similar types of questions trickling in. One of the areas that pops up, Candy, is, let's just say, whether you're using a manual process or a digitized application to support the field or support compliance, like the one you're seeing on screen here, what happens if an error is discovered, right? What are the immediate steps that need to be taken if there is some form of an error?
Yeah, so if you do discover error, I think obviously, there can be many aspects, right? Was it a disclosure error? Is it a truly to do with the recommendation not being in the best interest? There are different aspects of what type of error, but yeah, you would need to determine at that point, is this the type of error that is actually going to cause a correction with the client? Is it a financial error? Is it a disclosure error? And then what do you need to do to make that right on the client side? Then the other part of that is, according to the rule and the preamble information that the DOL has provided, does this require you to self-report it to the DOL? And I think that's one of the things that makes a lot of people nervous, is this whole self-reporting aspect. And do I really need to tell them that, or do I really have to disclose this? And I think that's very important. If you find some mistakes, to go back and really dig back into that rule and the preamble, and get comfortable with what you need to self-report and what you don't need to self-report. And then at a minimum, regardless of what the mistake is making sure you provide good records, detailed information about what you found, what you've done to correct the error. If you decided it did not need a self-reporting, make sure you document why you made that decision, how you reached that decision. You're not going to remember that in a year or 3 years from now, if it comes back to be reviewed. And then take a look at your process. What needs to be modified? If you found an error, what needs to be modified, or what training needs to happen to ensure this doesn't happen again? And I think a lot of times it may go back to what we've discussed already, is do you have a good process that's repeatable, or is it just kind of arbitrary, and each person is just supposed to make their notes and say that they've reviewed these things? It's definitely easier if you have a streamlined process, and if you find a mistake, then you can fix that streamlined process than to have a lot of different processes going on. And then I think ultimately that's really the reason for this annual review, right? Is, are there mistakes? Have you missed something? Have there been recommendations that haven't followed the exemption? Do you need to self-disclose those? And how effective are you? So I think that's the entire thing. That's really what we're doing in this retro review, is determining if there are any errors out there, if they exist, and then how to approach those.
Parham, just on that real quickly to follow up, because it's what I've seen a number of questions come in here, and it's the question that I hate answering because I don't have a great answer for it. It's like, and Candy, you alluded to it. It's like, well, what's reportable and what's not, right? And unfortunately, it's just not a ton of guidance and what things have been reported and what have not. You know, I think you have to use discretion there. A technical reading would say any violation of the exemption needs to be self-corrected and reported to the DOL. I don't think that's what's intended. I would just be reasonable, and to Candy's point, document your reasoning for reporting and not. The important thing, though, is that reporting is not the only self-correction thing that you need to do. If there's either no losses to the customer, or if there are losses, that you make them whole. So in any case, I would make sure that that's done. The correction has to be done within 90 days of it being identified, and you have to report it to the person who's doing the retrospective review. So unfortunately, the reporting piece, there's still a lot of gray out there. I've not seen any, definitive things that have provided a ton of light on that. But the other pieces, I think it's really important that you make sure that you get those right, because this is an exemption, right? And if you blow the exemption, you can't avail yourself of the exemption. So you have to really make sure that you're treading carefully there.
Thanks. That's super helpful. And Candy, very, very thoughtful remarks there. Maybe I can ask one more kind of question to you, Teresa, before jumping into our lightning round Q&A from our audience. Teresa, you've led this winding road from Reg BI implementation to PTE 2020-02. There's been overlapping requirements. Any key learnings you want to share with our audience today?
I think if I had to look at it, you can't have one without the other. You can't have peanut butter without jelly. Maybe some people can. I can't have peanut butter without jelly. Preferably grape jelly Welch's. Sorry, that's my commercial for the day. It comes down to doing what's in the client's best interest. What is best for your client. I'm big on documentation. Again, if you look at the SEC's March guidance, documentation isn't required, but it's highly recommended. That is a best practice. Making sure your disclosures are what's in line with your firm, with your clients, with your business practice, and that it meets the rules and the exemption. Looking at alternatives, making sure that you're looking at cost, even though cost isn't the only thing, making sure that you're looking at those alternatives. I've already talked about account type choices. What's in the best interest of your client? Is it a commission-based account? Is it a fee-based account? And when you're looking at cost, looking at the underlying cost, tax consequences, now and later, and that was one of the things that, especially in our world, we're so ingrained with, we don't give tax advice. Well, now we have to think about those things a little bit more fully without crossing that line. The Form 5500, we've talked about that and the importance of the comparison to a proposed plan or IRA rollover. Lowest cost, not always the best option for your client, and if you are picking something that's in the higher cost, why is that in the client's best interest? So again, it always comes down to what is in your client's best interest, documenting the rationale as to why that's in your client's best interest. And I saw a question earlier, does your client have to sign these disclosures? There's nothing in the exemption that says the client has to sign the disclosure. We don't require our client to send it, but we do track and monitor that goes out to the client. We use an automated system to do that through email. We can even see if the client opens that disclosure that we sent. We also require it and review it if we're opening an account. If it's not there, the account doesn't get approved for account opening. If there's new money that shows up in an existing account, I like to call that magic money because nobody knows it's coming. It just showed up. It was magic. you have a certain time period before we will restrict that account from doing anything, and that is centrally supervised. So just making sure you do what your processes say, and your processes say what you're going to do. So follow that, review them regularly, review your disclosures, update them. So I think those are all things where there's overlap and combination. FINRA is going to come in and they're going to look at your rollovers. They may not look at it from the exemption perspective, but they're going to look at it from a Reg BI perspective. So you need to make sure that they're in line.
Fantastic, Teresa. Thank you, and thank you for the analogies. Peanut butter and jelly, and then magic money. I'm gonna use those against you. Candy,
I might need lunch.
Any thoughts, Candy? I don't know if you were trying to say something. I just want to double check.
Yeah, before we wrap up and go to the Q&A, I just wanted to make sure to highlight one point and something that I'm seeing and helping my clients with performing their first review here is making sure that when you go to do your testing, that you're actually pulling the full possible universe of possible rollovers. Like, are you pulling a report of all deposits that came into IRA accounts or rollover accounts? I think you can be short-sighted if you just rely on the analysis that have been provided for a recommended rollover. You may miss some that someone may have considered wasn't a recommendation when they really were. So you just need to make sure that you are pulling in all of the appropriate data to get a good test of what really could possibly have been a recommendation.
And I would say one thing there, Candy, and thank you for bringing that up. Don't forget ACATs. It could be an ACAT transfer in, because don't forget the DOL is looking at those ACAT transfers. So it's not just money. It could be a transfer of assets. It could be the securities that came over from one firm to another.
This is fantastic insight. Really, really good points. I'm sure our audience values it. And speaking of which, let me, folks, put on your lightning round respondent hats on, because we're going to jump in. We've got sort of 7 minutes to rock and roll through some of these questions. Let's start with a generic question. How do you handle a rollover which comes in, which the advisor was not aware was coming in and was completely initiated by the client? Any thoughts on that?
I'll take that one. That's what I call the magic money. They didn't know, they weren't aware. We would consider that, if it just came in, the account was open, depending on the circumstances. If you're making a recommendation as to what to do with that money, so now you're making a recommendation. Are you trading? Are you moving that, depending on, did it come into a brokerage, a commission-based account? Did it come into a fee-based account? There had to be a conversation. The client probably called you for the account number. The client, we're going to drill down and ask more questions to find out what they knew, when they knew it, and how they knew it, to determine if that rollover form was actually required. More than likely, we're going to require that a rollover form be sent to the client after the fact, at least within 10 days of those funds or assets being required, to provide the client with the information, disclosures, and the fiduciary disclosure, so that they understand at a bare minimum that we are a fiduciary, that they may have had other options, what our conflicts are, and then, any updates on our fees and services or anything like that, because those are the reclosures that we would send out for a new account.
That's super helpful, Teresa. Thank you. Let's talk a little bit on the retrospective review requirements. Can a chief compliance officer certify the review if the compliance officer and assistant completed it?
I'll take that one, because I was actually able to look that up in the meantime, and I found an answer. So this is the one answer I think I can feel confident answering, because it's in the preamble in the Federal Register, but it does say that a senior executive officer is defined as any of the following: the chief compliance officer. So the answer is yes. The chief executive officer, president, chief financial officer, or one of the three most senior officers of the financial institution. So it's footnote 28 in the Federal Register, but those are the what would be considered appropriate for signing off on the certification.
Super helpful. There's a lot of questions around signature being required. I think Teresa, you touched on that on the recommendation. I'll provide my opinion quickly. When an account's being opened, that's when you need a signature. When a recommendation is being made, I don't know if you necessarily need a signature, but I think it fundamentally comes down to sort of your risk tolerance as a firm. Any thoughts on that?
So we require a signature when you sign a client agreement, but the disclosure in and of itself, the exemption doesn't require the client to sign the disclosure. That's what I was referencing.
Got it.
It comes down to being able to document the delivery of the disclosure.
Correct.
Fantastic, which is exactly what technology is there for, I'd say. One more quick question on the June 30th, I guess the senior exemption, senior executive certification date. The scenario is this: so within 6 months of the review, is it within 6 months of the review that the senior executive needs to certify the analysis? I heard some feedback.
No, and correct me if I'm wrong, it's the certification needs to be done at the end of, or by the date that the report is required to be completed, which is within 6 months of the period being reviewed. So you don't like do the review and then have another 6 months to get the certification.
Got it. That's super helpful, Ed. And maybe if we have time for one more, this last one that trickled in. If an advisor recommends that an existing client move an existing IRA advisory account to another advisory account type, will this be considered an IRA to IRA transfer and need a rollover disclosure?
Here, we consider that if it's the same fee structure, then no. But if you're going to a different fee structure, so that we have more than one advisory type. So if you're going to a different fee structure, or we would require, and we may be more on the conservative side. We tend to be that way. So that is our interpretation. So please remember that. Check with your legal counsel, check with your consultants. You may have a different interpretation, but that's how we've chosen to interpret that.
Thank you, Teresa. We've got 2 minutes left, so let me just jump into one more question. We've got a lot of questions around account type. Is it correct that account type is fee-based versus commission-based and not account registration of rollover, i.e. IRA versus Roth IRA? Any thoughts on that? Getting into the weeds here.
I thought I threw an answer out there on that one too. I would say it's fee-based versus commission-based, as well as if you're moving from a 401k to a Roth, are you moving to a traditional? You know, those are different types of structures. But again, that is our interpretation. You know, Ed, you may have a different interpretation. Candy, please feel free to chime in.
That sounds right to me.
Fantastic, folks. We're just at the 2 o'clock mark according to my computer. Thank you all very much. Ed, Candy, Teresa, Mr. Barnes, always a pleasure. We'll have recordings as well as the content here available for all to download after today's session. Have a great day.
Thank you.
Thanks, guys.
Take care.